आप भी कोर्ट कचहरियों के चक्कर लगा लगा के परेशान हैं या अपने सारे बैंक अकाउंट का पैसा लॉयर्स की जेब में देकर? अगर आप जानना चाहते हैं कि आप कैसे बच सकते हैं इससे, तो आइए हमारे साथ। हम आपके लिए लेके आए हैं मीडिएट गुरु। मीडिएट गुरु एक ऐसा प्लेटफॉर्म है जहां आपको न लॉयर्स के चक्कर लगाने पड़ेंगे न कोर्ट कचहरियों के। आपका पैसा भी बचेगा और आपका टाइम भी। आप यहाँ मीडिएशन के माध्यम से अपने प्रॉब्लम को सॉल्व कर सकते हैं। अब ना आपको कोर्ट कचहरी जानी पड़ेगी, ना किसी लॉयर के पीछे घूमना पड़ेगा। मीडिएट गुरु की हेल्प से आप अपने घर में बैठकर थर्ड पार्टी की हेल्प से अपनी प्रॉब्लम को सॉल्व कर सकते हैं। मीडिएशन एक ऐसी चीज है जिसकी हमें बहुत आवश्यकता है, क्योंकि आजकल हम अपने टाइम को ज्यादा वैल्यू देते हैं। टाइम इज मनी, सो मीडिएशन इज अ ग्रेट वे टू सॉल्व आवर इश्यूज। तो आप हमारी वेबसाइट में जाकर हमसे कनेक्ट होकर अपने प्रॉब्लम का सॉल्यूशन पा सकते हैं। धन्यवाद।
Hello everyone, we'll be starting with the session shortly. Thank you for your humble patience.
क्या आप भी कोर्ट कचहरियों के चक्कर लगा लगा के परेशान हैं या अपने सारे बैंक अकाउंट का पैसा लॉयर्स की जेब में देकर? अगर आप जानना चाहते हैं कि आप कैसे बच सकते हैं इससे, तो आइए हमारे साथ। हम आपके लिए लेके आए हैं मीडिएट गुरु। मीडिएट गुरु एक ऐसा प्लेटफॉर्म है जहां आपको न लॉयर्स के चक्कर लगाने पड़ेंगे न कोर्ट कचहरियों के। आपका पैसा भी बचेगा और आपका टाइम भी। आप यहाँ मीडिएशन के माध्यम से अपने प्रॉब्लम को सॉल्व कर सकते हैं। अब ना आपको कोर्ट कचहरी जानी पड़ेगी, ना किसी लॉयर के पीछे घूमना पड़ेगा। मीडिएट गुरु की हेल्प से आप अपने घर में बैठकर थर्ड पार्टी की हेल्प से अपनी प्रॉब्लम को सॉल्व कर सकते हैं। मीडिएशन एक ऐसी चीज है जिसकी हमें बहुत आवश्यकता है, क्योंकि आजकल हम अपने टाइम को ज्यादा वैल्यू देते हैं। टाइम इज मनी, सो मीडिएशन इज अ ग्रेट वे टू सॉल्व आवर इश्यूज। तो आप हमारी वेबसाइट में जाकर हमसे कनेक्ट होकर अपने प्रॉब्लम का सॉल्यूशन पा सकते हैं। धन्यवाद। क्या आप भी कोर्ट कचहरियों के चक्कर लगा लगा के परेशान हैं, या अपने सारे बैंक अकाउंट का पैसा लॉयर्स की जेब में देकर? अगर आप जानना चाहते हैं कि आप कैसे बच सकते हैं इससे, तो आइए हमारे साथ। हम आपके लिए लेके आए हैं मीडिएट गुरु। मीडिएट गुरु एक ऐसा प्लेटफॉर्म है जहां आपको न लॉयर्स के चक्कर लगाने पड़ेंगे, न कोर्ट कचहरियों के। आपका पैसा भी बचेगा और आपका टाइम भी। आप यहाँ मीडिएशन के माध्यम से अपने प्रॉब्लम को सॉल्व कर सकते हैं। अब ना आपको कोर्ट कचहरी जानी पड़ेगी, ना किसी लॉयर के पीछे घूमना पड़ेगा। मीडिएट गुरु की हेल्प से आप अपने घर में बैठकर थर्ड पार्टी की हेल्प से अपनी प्रॉब्लम को सॉल्व कर सकते हैं। मीडिएशन एक ऐसी चीज है जिसकी हमें बहुत आवश्यकता है, क्योंकि आजकल हम अपने टाइम को ज्यादा वैल्यू देते हैं। टाइम इज मनी, सो मीडिएशन इज अ ग्रेट वे टू सॉल्व आवर इश्यूज। तो आप हमारी वेबसाइट में जाकर हमसे कनेक्ट होकर अपने प्रॉब्लम का सॉल्यूशन पा सकते हैं। धन्यवाद।
Hello, everyone. On this day, I, Kavya Buddhiraja, extend a warm welcome to you all to this international webinar on the topic ADR versus ODR, or Alternative Dispute Resolution versus Online Dispute Resolution. It is indeed my privilege and pleasure to be the moderator for this session. Now, let me begin by giving a brief introduction of our organization, MediateGuru. MediateGuru is a social initiative led by its members all across the globe. The aim of our organization is to bridge the gap between general public and litigation. And here, our organization comes into picture. We are creating a social awareness campaign for showcasing mediation as the future of alternative dispute resolution with a view to provide ease to the judiciary as well as to the pockets of the general litigants. Now, let me take this wonderful opportunity to welcome and introduce you all to our esteemed speaker for the event, Ms. Fidana Alieva. Ms. Fidana is a regional mediator for the Compliance Advisor Ombudsman World Bank Group. She's also mediator, ADR-ODR International, United Kingdom, Weinstein Jan's International Senior Fellow. She is the founder and Director General of Center for Mediation and Negotiation, LLC, an arbitrator and mediator for the International Court of Arbitration in affiliation with the Chamber of Commerce and Industry of the Kyrgyz Republic. She also holds a distinct specialization in commercial, labor, and family business disputes settlement, ADR and ODR. Ma'am, we extend a warm welcome to you. Thank you so much for joining us here today and graciously accepting our invitation. Thank you, ma'am, once again. So without taking any further of your time, may I now request, ma'am, to kindly carry the session forth and enlighten all of us over the issue. Over to you, ma'am.
Good evening, good morning, good afternoon, everyone. Thank you, dear Kavya, for kind introduction of me. Sorry for my pronunciation. I hope everything is understandable. I'm not a native English speaker. My first language is Russian. If something is not understandable, just let me know and I will repeat it. I thank you all the attendees for the interest in this really interesting topic, ADR versus ODR. So before we get started, I would like to say that the whole world faces great changes. Dispute resolution system is also going through a certain change. So let's make this change positive. Let's get started. I will share with you my screen to demonstrate you the presentation. Hope you can see it. So let's start with ADR. What is ADR? ADR is alternative dispute resolution, which includes three main models: negotiation, mediation, and arbitration. There are some additional models like hybrid ones, mediation, arbitration, arbitration, mediation, and arbitration, mediation, arbitration. But if to speak about these three ones, they have some similarities and differences. If to speak about negotiation, usually it's a voluntary process without participation any third parties. Usually there are just parties to the conflict or dispute. Process and result are controlled by the parties fully. It is confidential process if we talk about official negotiation. And the main focus is on positions and interests. The second one is mediation. Mediation can be voluntary and mandatory. Mediation means that there is a third neutral party called mediator. So in the process, there are several participants, parties, and or their representatives, and mediator. Process is quite flexible. The process is controlled by mediator, and the result is fully under of the parties. It is also a confidential process, and the main focus is on the interests of the parties. And if to speak about arbitration, arbitration can also be voluntary and mandatory. Arbitration means that there are a panel of arbitrators, of 3 arbitrators, or there could be 1 arbitrator. There are parties and their representatives. Process and result are controlled by arbitrator or arbitrators. Usually it is confidential process, and the main focus is on positions with their legal rationale. Just a second. I understand that most of the participants today are lawyers or future lawyers. And for example, if you are a lawyer and you don't want to become a mediator, could be a lawyer which could bring own clients to mediation process, as well as you bring your clients to court proceedings. And the problem is what to choose if we speak about alternative dispute resolution. I have practiced in about 300 cases. Most of them are mediations and negotiation and several arbitrations. So, and of course, if we are talking about process with the third party involvement, I would recommend mediation, because mediation for me is the art of settling the most complex cases. It is quite flexible. It is a very creative process. And usually this process brings certain insights to the parties while mediating, which helps them to make mutually acceptable agreement as a result. Mediation is applicable in many different cases. So let's go through the list of some of them. Contract disputes, family business issues. The stakes are high. Relationship between disputants is important. There is interest in attracting investors. Issues is not being settled during long period of time. There are reputational risks. More than 2 parties are involved in tense negotiation. There are some doubts in ability to prove own case, and there could be some influence on third parties not involved in a dispute. So this is a small list of those cases that should be or could be applicable to mediation. What are advantages of mediating? So I did not forget that the topic of our conversation today is ADR versus ODR. I'm going to speak about mediation. From the perspective of mediation as ADR and ODR. That is why I'm talking about mediation. So what are the advantages of mediating? Confidentiality is ensured. Self-determination is a fundamental principle, which means that parties make the decision on their own, and this decision should be mutually acceptable. No loss and no failure. Even if the parties do not settle the case in mediation, nobody loses. And even then, there is a great advantage of mediation process because they get enough information to improve their legal positions if they plan to go to court after mediation. Reputation, safety, and saving face, which is very important when we talk about commercial cases. Better and fairer result. Better because in mediation process, mediators spend quite a lot of time with parties analyzing and discussing different options, not the only one option, and different alternatives. Some of you know BATNA, the best alternative to a negotiated agreement. And this is as a result bring, but as a consequence, bring better result. And one more very good advantage of mediation, enforceability of agreement. In more than 80% of the cases, the settlement agreements are enforced and abided by the party. And you would ask me why? Because mediation is a voluntary process, and when parties take the decision voluntarily, they discuss different options and choose the one that is most acceptable for them. Usually, after the mediation, after the agreement is signed, they follow this agreement, and the agreement is enforced. So today, mediation is becoming more and more popular as ADR and ODR. And there are several reasons for that. 40 years ago, nobody knew what is mediation, and mediation was just a try of several people. Today, mediation is a technology and procedure at the same time. There was time when mediation was not regulated at all. Today, there are mediation laws and provisions in many countries. Before now, mediation was applied in inner dispute settlement only. And today, mediation is used as a conflict resolution method to settle international and trans-border issues. So keeping in mind Singapore Convention, which was signed last year. So now let's talk about ODR. What is ODR? In fact, ODR is the same dispute resolution, but in different environment. Many mediators now, which get used to mediate face-to-face, find ODR overwhelmed. I no doubt there are some mediators here online that when they started their mediation practice, mediation also seemed to be something very complex and is not possible when we're talking about helping parties to get to mutually acceptable agreement. But it was about practice, and when you practice for several months, several years, you understand that it is possible. You just need practice. The same with ODR. ODR is the same alternative dispute resolution, but in online format. And let's think proactively. What are the advantages of mediating online? And there are many advantages of mediating online. First one, confidentiality provided by special technical developments. There are virtual rooms, for example, if there is a need to provide private sessions, there are virtual rooms for joint and for private sessions. Mediating online helps to decrease emotional tension between the parties because physically they are not in the same room and they are not in the same building. And this helps them to be less stressful. Opportunity to select a mediator from any country. Yes, now it's possible because when mediating online, we really can choose any mediator, any lawyer to accompany a party in a mediation process. And this will be even cheaper if to invite a mediator from different country because there are no travel and accommodation expenses. Mediating online saves about 20% of expenses. And when we are talking about online mediation, it means that there should be an online platform and there are different options, Zoom, WebEx, Modron. Now, currently, I, with my colleagues from Russian Federation, we are working on international online platform, which is developed on the basis of Russian Silicon Valley called Skolkovo. So there are different options, and you can choose any option. So those which are of high quality, they include multilingual function, which means that if parties and mediators speak different languages, so it's not a problem now when they're mediating online. This slide was in my previous presentation for Bangladesh International Mediation Center, and I decided to repeat it again about prospects of online mediation. So before pandemic, mediation online was one of the options which was used rarely. During pandemic, during the crisis, mediation online is the only option to use. And I have no doubt that after the pandemic, mediation online will be one of the options actively used in 70–80% of the cases. I think if to talk about ADR versus ODR, we should think in a collaborative way, in my view. And ODR is not a contrary to ADR. It is its continuation. It is the same alternative dispute resolution. Why to choose one? We can choose both. We can use advantages of both methods. And just in general, they're the same. Just online format requires some technical preparation of the process and ensuring confidentiality principle. You are the new generation of lawyers, dispute resolution professionals, and I have no doubt that in future, one day you will bring this alternative dispute resolution and online dispute resolution to much higher level than it is now. This was briefly about ADR and ODR. I hope it was useful and somehow helpful. Now, if you have questions, I will be happy to answer them. I hope Kavya will help me to pick up the most interesting questions and answer them. I see one question from Akbar Hanzada. Do you think ADR should be made mandatory before a trial? You see, in some countries, mediation, which supposed to be voluntary, became mandatory, but not all understand what does it mean. So if there is a mandatory initial meeting before a trial, and I think it is very helpful, because mandatory initial meeting does not mean that parties should mandatorily stay in the process and mediate. It means that they should try, that they should participate in a first initial meeting with mediator to understand what mediation is, how mediation could help them to settle their issue. And if they don't want to continue, it is their right. I think in this sense, mandatory initial meeting is very helpful, because most of the lawyers, especially in developing countries, they don't know how mediation works. I mean, I'm talking about lawyers who represent their clients. And when they bring the clients to mediation, to this first initial meeting, they get understanding of what mediation is and how does it work. And very often they stay in mediation and they settle. So As per you, there is no such difference between ADR and ODR, so are they supplementary as well as complementary to each other? Yes, I think ODR is complementary to ADR because, as I said, the process is the same. The stages of mediation are the same. I tried mediating online and arbitrating online. The process itself the same. There is need for special technologies, for special platforms, and you need to think about ensuring confidentiality issues. So this needs preparation, but in general, the process is the same. Why people? What, according to you, is the reason why people prefer traditional trials over mediation and arbitration? In my view, mediation and arbitration are quite new in most of the countries. Mediation is very popular in the US because it has been developing for more than 40 years by now. But in our countries, including Kyrgyzstan, it's new. And of course, when there is something new, it's about discomfort zone for people. They need to know about it more. They need some information campaign about mediation. So we, as dispute resolution professionals, should inform people appropriately about what mediation is, how does it work, what are the advantages. We should inform about how to choose the right method for this or that case, because not all the cases are subjected to mediation and mediation should not be applied in all the cases. Mediation is not a remedy for all the illnesses and difficulties. But in many cases, mediation should have a try for parties, and they should try it first before going to trial. So I think time will pass, and in several years, in some countries in 5 years, in some countries maybe in 10 years, mediation will be more popular, and people will see that it brings very good results, and they will apply to mediation more and more often. So there is need for time. How confidentiality ensured in ODR? First, it should be specified in laws. For example, in many countries, including post-Soviet countries, which have mediation law, there are some changes to the will be made in the nearest future, because this should be written in laws that ODR is possible and how confidentiality principle could be provided. The second thing, those platforms, they have special technologies to provide this confidentiality. For example, if we're talking about Zoom, there are passwords that are given to the parties only, and nobody can enter the room. All the documents could be signed, and they are signed online. But again, nobody has access to those documents except parties, their representatives, and mediator. It's about law, about changes to laws, mediation laws, and about technology. My question, because I have read whether judge can give question from ADR. Good evening, ma'am. My question is whether judge can give an order to both parties to take ODR, because I have read that only arbitrator or mediator can settle the outside cases. For example, in our law, we have a point according to which judges could refer parties to mediation if it is applicable to mediation. So they do, not in all the cases, but sometimes they do, and parties go to initial meeting, but it's not mandatory. In some countries, there is mandatory reference by judges parties to the mediation, to this first initial meeting, and in this case, parties cannot refuse. In our case, in my country, it's like a recommendation to the judges, so they can refer and they cannot refer, and parties can refuse to attend first initial meeting. So it's about how it is written in the law. But in fact, if there is mediation and a certain judge understands how mediation works, and the case is applicable to mediation, why not? I think judges should refer cases because they are very loaded. There are a lot of cases on each judge, and in this case, mediation could help. Which one is preferred? Question from Priyanshu Panda. Sorry if I don't pronounce your name correctly. Which one is preferred most of the time, ADR or ADR or ODR? So, as I have mentioned in my presentation, now during crisis, ODR is most preferable in most of the cases. But for example, in several countries, after the lockdown, some turned to hybrid ADR and ODR. So they can start from ADR and then turn to ODR. They can sign agreement to mediate face-to-face, and then they turn to ODR and conduct mediation process online. I have experience when, for example, in one mediation, I used face-to-face meetings, online format, emails, and phone calls, and it was okay. Then do you think that this kind of process infringes upon the rights of the parties that is owed, as ADR focuses on setting rather than getting what they are legally owed? How would you convince a client to take the ADR route instead? You see, it's up to the parties to choose any method that they would like to choose. But before choosing, they should understand what is the core of their case, what is arbitration, what is mediation, and how would it go in mediation, in arbitration, or in court proceedings. When we talk about mediation, just let's talk about mediation and arbitration. Even in arbitration, parties and their representatives, they are mostly focused on legal positions. In mediation, I don't say that legal positions that they are ignored. No, because mediation could not contradict the law. But in mediation, the main focus is on their interest. Everything is taken into account: their needs, their interests, their legal positions, their thoughts, their opinions, and mediator is a person, is a professional who differentiates all the information which is received from the parties. I can say that a lawyer or somebody else or a judge should convince a party, a disputant, to go to ADR. A lawyer or a judge should give right understanding of what mediation and arbitration is, or what is trial. And it's about party to choose. what will work best. Okay, let's go further. How arbitration, mediation, and negotiation different from each other? It was our first slide, if I'm not mistaken. So I will briefly repeat again. Maybe you joined later. So arbitration, mediation, and negotiation are three alternative dispute resolution methods. When we are talking about from which to start, it's better to start from negotiation. When parties negotiate with each other, if they don't settle, then they need a third party, a professional, a neutral who could help. It means mediation. Then they go to mediation. If they cannot settle in mediation, then they go to arbitration. Usually, this is the right stages to dispute resolution, to any dispute resolution. All these three methods have similarities, like all three processes are confidential, voluntary, but as I have said at the beginning of my presentation, mediation and arbitration, they can be mandatory in some countries. They save time, they save money, all three. But you should understand that the fees are becoming more and more high from negotiation to arbitration. So what else?
Ma'am, there's a question by Manvendra Verma. He says, ma'am, please address my question. Do you consider mediation or other ADR method as an efficient and suitable method for settling international trade disputes with pharmaceutical products? And if you think so, then why?
I think yes, and I have mentioned that some time ago, let's say 10 or 20 years ago, mediation was used in some countries for resolution in a disputes only, I mean, within a state. Now, mediation can be used for transborder and international dispute resolution, including international trade disputes. Most of you know that last year, Singapore Convention was signed. As I know, by now, 52 countries have signed it, and 6 or 7 have already ratified. So it came into force. I think there is a need for time to this convention to start working, because there should be appropriate mechanism which will regulate those kind of disputes. But in my view, mediation is applicable for international trade disputes, because it is applicable for international disputes, for complex international disputes where more than 2 parties even involved. So my answer is yes.
Thank you, ma'am. Ma'am, the next question has been put forward by Aditya Shah, who strives to ask the skills required in order to become a good mediator. What are the skills?
You see, the skills. So when you attend any mediation training, you can get a technology, special techniques like active listening, answering good questions, stages of mediation. It's about the process. But skills, they can be worked out only when you start practicing mediation skills. In my opinion, the most complex is to be neutral, because we are all human beings. And you see, even for example, you are a woman, and there are 2 parties. One party is a woman, and the second one is a man. But you need to be neutral. And sometimes it's really, really complex, and it takes a lot of time to develop your inner neutrality. Some mediators say that it's not possible to be neutral. It's better to say independent. And maybe to some extent, I would agree. There are some three things that I've recently heard from Deepak Chopra. He was talking about meditation, and he was talking about 3A: attention, appreciation, and acceptance. And all three are applicable to mediation, because as a mediator, you need to give equal attention to all the parties, to feel them comfortable with the process and with you as a mediator. You need to appreciate them for their try to come to mediation, for their readiness to speak to each other in this difficult for them situation, and acceptance, which means that as mediator and as being neutral, you cannot judge them as a parties to the dispute, and you cannot judge any options that they will choose. You need to help them to analyze the options that they have, and to help, not to choose for them, but to help them to choose the most acceptable, the most beneficial for all the parties. And it's all about neutrality. You need to feel comfortable. Sometimes you need to behave like a child, because when you have you have your own picture of this situation, and in this case, you will bring them to the root you see, and it's not right, because they have their own puzzles. You need to help them to put those puzzles together to have their own picture, and this will work.
Right. Thank you, ma'am.
Mm-hmm. Okay. Any other questions? Actually, there are a lot of questions, but there are also some comments. So
it's difficult to make out which one is the question and which one is the comment.
Yeah, where is the comment? Where is the question?
I think the question of Mr. Joseph has already been answered by you. Do you have a special approach or a style in mediating the clients? I think that's what you just answered.
Yes, but I will add. There are several mediation styles, but there are two main ones: facilitative style and evaluative style. In most of the cases, I start with facilitative style. But in commercial cases, there is a need for evaluative style as well. But it does not mean that I evaluate the parties and their case. No. There are some other elements of evaluative style, like working mostly in caucuses, private meetings with parties. So, and for example, if a party asks you as a mediator somewhere in the middle of the process, so I would like to offer them this sum of money. What do you think? Would they agree? Would they accept it? So, and if I, being in a private meeting with that party, and I've heard that they would agree for the sum that is much bigger, I would, in a very slight way, explain that there is a need to analyze the situation again and to think what will be the reaction of that party to this sum, just like this. And this is evaluative style as well.
Right. Thank you, ma'am.
Okay.
The next question is by Rifat Ahmed. The question is, now that we know the importance of ADR and ODR, now what all steps or activities should a current law student take in order to become, an arbitrator or a mediator? What can he do current, like in the present scenario? What can he do currently?
I think you have much, as a student, if you are a student, you have much more information that we had when we were students. You have much more information about ADR. You have an opportunity to have conversations with those who already mediate and arbitrate. You can ask questions. If there is a chance, you can ask those mediators who are in your region to shadow them in a real mediation process and to have this one of the best experience. I had this experience during my Weinstein GEMS International Fellowship in San Francisco, when I shadowed greatest mediators which have experienced 20 plus years. And those cases were for millions and billions US dollars. And it was great experience, different styles, different approaches, and great experience. So if you have such an opportunity, and if you know personally mediators or arbitrators, if there is any chance to shadow them, just try to shadow them.
Thank you, ma'am. The next question has been put forth by Mr. Prashant Kumar. He seeks to ask whether conciliation is also included into ADR or not.
You see, conciliation, when we're talking about conciliation, I take conciliation as one of the court methods, because there are judges who conciliate. In our countries, very often mediation is confused with conciliation, and it's not correct, because mediator is not a person who helps parties to make a peace. We don't make peace. We help parties to settle. When they come to mediation, it's a rare thing when they need peace. They need to settle certain issue. So our role is to help them to settle their issue, not to be peaceful to each other. It can be a consequence when parties after the mediation process, they come to peace. And for example, there was a family and they stay as a family, or for example, there are business partners and they were going to split, and they planned to make a business divorce, but they stay together after mediation. It could happen, but it's not a mediator's role to bring them to that. So in my opinion, conciliation is mostly used in court, but not as mediation or negotiation, or let's say arbitration.
Thank you, ma'am. The next question we are about to take is regarding your own personal experience, which has been put forth by Mr. Vikram Singh. The first question: can you please tell a little about your experience with the Compliance Advisor Ombudsman?
So you see, the Compliance Advisor Ombudsman has a panel of mediators, and last year I went through a quite complex competition. So they were looking for mediators around the world to include them into their panel of mediators. The cases which are considered within Compliance Advisor Ombudsman office, they are usually quite complex, and these are the cases which it's not a 1 or 2 or 3 sessions. It's usually several months or maybe 1 year, sometimes 1.5 year cases. And usually there is a group of mediators consisting of 2 or 3 mediators who help to settle those complex issues. Just briefly.
Thank you, ma'am. So the last question for this evening would be how to start an arbitration center of your own.
Arbitration, not mediation. So if you want to start, I would recommend you to start ADR center, not only arbitration center. I mean, and not to include arbitration only, because if it's ADR center, you can have clients for mediation, for negotiation, and for arbitration as well. And I have mentioned about hybrid procedures: mediation, arbitration, arbitration, mediation, which are also used and quite successfully, not in many countries. But I do hope that one day in my country we will also use those hybrid procedures. So just register ADR center. This is my recommendation, not arbitration center. Then you will have much more opportunities, because as I have said, mediation is getting more and more popular, and I have no doubt that in future mediation will be even more popular than arbitration. The future belongs to mediation.
Thank you so much, ma'am. And with this, we come to an end to this question and answer session. I am really apologetic to all those participants who were really keen to get their questions answered. But then due to paucity of time, we're only able to take only these much questions. We're really sorry to all those whose questions we missed on to. So
thank you so much for your interesting questions. Those of you who still wants to be answered, you can write to my email. I demonstrated it in my presentation. As for presentation, I will send a PDF version to MediateGuru, and they will distribute to all of you. Thank you very much for your attention. I wish you success in all your endeavors.
Thank you so much, ma'am. That was really humble of you. Thank you so much. It was really
an
interesting, informative and remarkable session. We really owe you this time.
Thank you. Hope to visit your wonderful country one day.
Yes, sure. We're really looking forward to that. So as all good things come to an end, and so has this session, I would like to extend once again my sincere gratitude to Ms. Fidana for taking your precious time out and agreeing to join your lovely evening here with us today. Thank you so much, ma'am, once again.
It was really a lovely evening. Have a nice weekend. Bye-bye.
Yes. And I would also thank, yes, ma'am. I would also like to pause who's from different parts all across the globe, and again, spending your lovely evening here with us today. Thank you so much to all the contestants once again. And just a small announcement, all the participants may kindly have a quick note that the certificates will be provided to you only after you complete or you fill up the feedback form that is already being provided to you in the chat box down below. And the certificate shall reach to you within 7 business days from now. Thank you so much once again, everyone. Thank you, ma'am. Thank you, all of you. Stay safe. Thank you.